Sure. So in a nutshell, and it doesn't matter what jurisdiction you're in, what American jurisdiction you're in, all 50 states, Washington, D.C., Guam, Puerto Rico, they all have their own self-defense statutes and jury instructions and court decisions, but it all boils down to the same 5 elements of self-defense. That just reflects how old and well-established self-defense law is in American law. And those 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. And innocence basically means you can't have been the initial aggressor in the fight, right? Self-defense is to defend yourself against someone else's aggression. Imminence means the threat you're defending yourself against is either actually occurring or immediately about to occur. It's not something that happened in the past. It's not a speculative future threat that may never happen. Proportionality involves the intensity of the force involved. Generally speaking, you can only use deadly force in self-defense if you're facing a deadly force threat. Deadly force in self-defense. Avoidance has to do with whether or not you're in one of the 11 states that imposes a legal duty to retreat before you can use deadly force in self-defense. Most states don't. Most states are stand your ground states. And then reasonableness. That's really twofold. You have to genuinely, in good faith, believe you need to act in self-defense. That's a subjective belief inside your head. But that belief also has to be objectively reasonable. A theoretical, reasonable, and prudent person in the same circumstances would have shared that subjective belief. So an irrational belief to act in self-defense is not sufficient for that element of reasonableness. And the prosecutor's job, when you're claiming self-defense to justify your use of force against someone else, their job, and they're well aware of this, is they have to disprove any one of those 5 elements beyond a reasonable doubt. Because the elements are cumulative. They're all required. If anyone is missing, if anyone is disproven beyond a reasonable doubt, you don't have a claim of self-defense because you're missing a required ingredient, a required element. And the prosecutor knows this, by the way. He knows he doesn't have to disprove your claim of self in its entirety. You could have 4 of those 5 elements 100%, but if you're missing any one of them, your self-defense claim collapses. And he knows that going in. So from a prosecutor's perspective, each of those 5 elements is his target of attack.
Gotcha.
Any one of them he can defeat, your claim of self-defense goes away. And that's a problem in self-defense because self-defense it's a legal defense of confession and avoidance. Because when you claim self-defense, you're not saying, it's not like an alibi defense. You're not saying it wasn't me, I was someplace else, right? I had nothing to do with this. You're saying the opposite of that. You're saying, yeah, I shot that guy. I killed him. So you're confessing not to a crime per se, but you're confessing to the underlying conduct that is the basis for the use of force charge. I shot that guy, I killed him, but I did it in lawful self-defense.
And you did it intentionally.
Intentionally.
Right? So it's not an accident.
Yes. So accident is a different legal defense. You can raise the legal defense of accident, like you can raise the legal defense of self-defense. But it's a very difficult legal defense when guns are involved, because guns are inherently dangerous instruments. Almost any mishandling of a gun that results in someone's death is going to be considered reckless conduct, which is enough for criminal liability all by itself.
Just to clarify the one point about the intentional act, it might be that you intentionally shot with the purpose of defending yourself, not that you intentionally killed the person. It could be the consequence of it,
right?
But that's not necessarily your purpose,
and it ought not be your purpose. I mean, whether or not this aggressor actually dies is not the mission. If you're acting in self-defense, your mission is to neutralize the threat against you or against other innocent people. In fact, I would argue that it's generally preferable if they don't die. If consistent with safety, consistent with neutralizing the threat, they don't die as a result of your use of deadly force. Because if they die, your potential liability, legal liability, goes up tremendously. Now you're looking at a murder charge or a manslaughter charge. If they simply don't die, those things are off the table because those criminal charges require that someone died as a result of your conduct. So if we could have, Star Trek taser guns that just, made people fall over unconscious instead of dying, that would be preferable. We don't really live in that world. Guns are, as I say, this is a guy who's carried a gun every day for personal protection. He's carrying a gun right now for personal protection. A gun is very rarely the answer to the problem you're facing. When it is the answer to the problem, it's generally the only answer.
Absolutely.
To the problem.
I didn't mean to interrupt you, but I did interrupt you. You were talking about reasonableness and you talked about subjective reasonableness.
Right.
That wasn't the whole story, though.
Well, it's subjective and objective. I think I was talking about confession and avoidance. So you're confessing to the underlying conduct and you're seeking to avoid legal liability through the justification of self-defense. Because if it was self-defense, it's simply not a crime. It's justified conduct. In that sense, self-defense is what we call a perfect defense. It doesn't just mitigate your legal liability. There is no legal liability. The conduct simply shooting that person which would normally be unlawful, is simply not a crime if it meets the conditions, the 5 elements of self-defense. But the risk there, of course, is because it is a legal defense of confession and avoidance. If the prosecution can destroy your claim of self-defense by disproving one of those elements beyond a reasonable doubt, then you have the confession and you don't have the avoidance. You don't have the legal defense. And so essentially all you've done then is provide the prosecution with a confession, and that's an easy walk-away conviction for the prosecutor. So in a normal criminal case, the prosecutor has to prove you guilty of the crime charged, right, beyond a reasonable doubt.
Yes, sir.
But in a self-defense case, you've effectively conceded to that if you don't have the legal justification of self-defense.